Welcome back to the channel. I'm Professor Will, your Director of Training here at Centurion Holdings LLC. And today I've got a special treat for you. I'm going to bring on a friend of mine. We're going to interview for just a few minutes here. And he's kind of an anomaly in my world. Not only is he a former full-time police officer, I believe he still works part-time as a police officer. He's also an attorney. I still like him. But Ben is a good dude. He's a martial arts guy, and he's going to give us some insights today that I think you're going to find really important. And if you're a martial arts person and worried about self-defense, worried about anything that you might have to use your martial arts outside of a competition, outside of your dojo, you need to watch this. Check it out. Hey, Ben, welcome to Centurion Holdings. How are you doing today, my brother?
I'm doing all right.
Good. I would like you to do me a favor and just kind of, I know your background, I know your history, and I know why you're an expert on the subject we're going to talk on today. But why don't you do me a favor and let my audience know just a little bit about your background?
Sure. I wear many different hats, and it depends on the day what I'm doing. I actually simultaneously hold the role of attorney and law enforcement officer and adjunct law professor. So it depends on the day as to what I'm doing. A little bit about my background. I started my law enforcement career in 2002 down in Rocky Mount, North Carolina. From there, I went out to the Dare County Sheriff's Office on the Outer Banks of North Carolina. Served in a number of roles there. I was a patrol corporal, was a field training officer, I was a school resource officer, I was a defensive tactics instructor. In 2009, I left full-time status with the Sheriff's Office. I'm still sworn there as a reserve deputy. I still travel twice a year to teach at the police academy as a defensive tactics instructor down in North Carolina. But I moved to Virginia to attend law school at Liberty University, graduated law school in 2012, and have been practicing in Virginia as a attorney since that time. Law enforcement was always something I never wanted to leave behind, and it wasn't enough for me to travel down twice a year and teach and just be a reserve. So in 2010, while I was still in law school, I joined Waynesboro Police Department's auxiliary police unit, and I have been sworn as an auxiliary officer in Virginia since 2010. I actually now serve as the deputy chief of the auxiliary unit in Waynesboro. Handle a lot of actually all of the auxiliary unit's training at this point. And since 2014, I've been teaching as a adjunct professor at Liberty University School of Law, both online and as a residential adjunct. So I teach at the law school itself, and then I teach online in the paralegal program and the Juris Masters program. I also teach in Virginia at the Central Shenandoah Criminal Justice Academy. I handle, since 2013, I've been handling all of their basic law classes for the police officers, and then the basic jail class for the jail officers. So twice a year I go up there, and I'll actually be there next week, all next week, teaching the law class. I also have a pretty long lengthy martial arts background. I started martial arts as I was in fifth or sixth grade. I'm getting old. I can't even remember exactly when that was. Fifth or sixth grade, Tung Sudo. And it was, I did that, got my black belt in Tung Sudo. But I remember we went over, one of the instructors actually was saying, hey, you guys got to see this new thing that's out there, it's Ultimate Fighting Championship. And they go in and it's bare knuckle, and they test the martial arts. And I remember seeing this skinny looking Brazilian guy in a gi, who I first thought, oh, it's a karate guy, he's in a gi. And then he was doing stuff that was like, what is that? Like he's wrestling. This is nothing like what we practice or what you see and Chuck Norris do in the movies. So it was UFC 5. I watched Hoist Gracie in the super fight with Ken Shamrock, and then just watching the other fights, how all of them went to the ground. I was like, I got to learn that stuff. And then back in the day, there wasn't a place you just couldn't go down the street and find a jiu-jitsu school. So I did some judo, which was as closest that you could get. Like it was reasonably close, and then learning from the VHS tapes and training partners, and then gradually over the years finding people who knew how to do jiu-jitsu. And then I now have a brown belt. Interestingly enough, it was Hoist Gracie that promoted me. So it kind of went full circle. So that's I don't know. Anything else you want to know about me? I'm pretty boring.
Ah, no, actually, I started laughing there during your bio because the Waynesboro is where I went to the police academy at
Yeah, you're in the
because
book. I saw you.
Central Shenandoah Training Academy was there
Yep.
in Waynesboro at the time, and I was one of the lead DT instructors there. So it's funny how our paths have crisscrossed,
Yep.
probably 3 years removed. But when they moved to Wayer's Cave, is kind of when we stopped going up there and went to the local one because it was just too far away for us. But
Yeah, it is. It is for us. That's why I stay up there when I do.
Ben is uniquely qualified to talk about our topic for today. One of the things we're going to talk about today is what happens with your martial arts training, a self defense situation, and how it can be translated into what happens afterward in the aftermath, and how during that self defense situation, you can go too far and go from being the defender to being the aggressor. And we both have some, as I did kung fu and karate, taekwondo stuff as a kid, and well up into my mid 20s or something like that. I was even still kind of like doing some of the kung fu when we started doing the Muay Thai and jiu-jitsu. And I'm with you on that. We had to drive 4 hours one way to Virginia Beach
Hmm?
to get training because that's the closest place we could find with Frank Cucci. It's the closest place we could find with any of that. Or I had to drive to Maryland where Mike Krivka was at to do stick fighting. There was nobody close. So we had to
Yep.
drive all of that. So give me some of your thoughts as a person who also has some traditional martial arts background there. Um, you and I have both seen, and I call it the fallacy of the martial arts training, little 1 step, 3 step sparring. The guy throws a punch and you go block. There's a punch, there's a kick, there's a block, there's a punch, there's a kick, there's an elbow, there's a knee, there's a headbutt. And it reminds me a lot of times of some of those skits done by like the Master Ken parodies where he's,
Yes.
doing like 10 billion things and killing people for, asking questions. What is your opinion on that kind of training or what that kind of thing, the fallacy of that? Tell me what you think.
So I've seen that over the years in the law enforcement defensive tactics side of things. Some of the techniques that they taught were based in traditional martial arts, and don't get me wrong, traditional martial arts have things of value, but sometimes those techniques make people have a false sense of security in what they know. Unlike the movies, when you strike somebody, that does not necessarily mean that that one strike is going to be enough to end the threat.
Yeah.
People are, some people are just hard headed. They can take a punch. Some people are amped up on pharmaceutical enhancements. Some people are just flat out crazy. And the reverse punch or the spinning heel kick that you do, you might connect with that thing, and they look at you, and then they come right at you again. And you can watch in the law enforcement side of things. A lot of the law enforcement training had traditional martial arts background where you did a lot of very complicated wrist locks. You did a lot of karate style blocks. And if you watch body cam footage, or I've seen encounters, the officers try to do that. They grab the hold of the arm and the wrist, and next thing you know, they're rolled up on the ground because the technique doesn't work under pressure. It's not pressure tested against somebody who's actively resisting and who might might be amped up on something or just crazy. And so the techniques that work are those that are pressure tested, that require gross motor skills, and they're forgiving techniques. They're techniques that don't require a lot of precision. They don't require, I got to grab the wrist at this angle and turn it this particular way and then bend it backwards in order for the technique to work. So the Hollywood and the movies have really put a false picture on what self-defense actually looks like. Fights don't look like choreographed, Chuck Norris scenes. They're messy. They're quick. They tend to be a lot of grappling tends to happen, and it just doesn't look like what you see in the movies. And so knowing how to engage in techniques that can control and not be excessive and can rely on that pressure tested gross motor skills is actually very important. It's one of the reasons I sort of switched styles.
You and me both. I had noticed that, and to add just my own little spin on what you were just saying, you're not only dealing with things that may not always have not been pressure tested, but you're also having it done by a person that got 40 hours or less of training and then never tried it again until they were trying to fight somebody, and then they're trying to do that wrist lock that
Yep.
they've barely understood, and that makes a problem.
Yep.
But you just used a word that I want to really key in on here about being excessive. So for my listeners who
Mm-hmm.
are not law enforcement centric or may not really have a lot of experience on that level of, you and I take that for granted because we've been doing the LEO side so long, but just kind of give a quick synopsis of what do you mean by excessive?
So any use of force, whether it be deadly force or non-deadly force, is always judged through a lens of it must be objectively reasonable. And so when I say objectively reasonable, objective means it's a a fictitious person who was inserted into that scenario, who was a reasonable person, who was a person who follows the laws, who does the right things, who is not a troublemaker. Would that person have engaged in the amount of force based on what they were presented with? And then did they only use the amount of force that was both reasonable and necessary to control and stop the threat? That's the standard that the courts use in judging any use of force, whether it be a law enforcement use of force or whether it be a civilian use of force. You must have, and it must be objectively reasonable that you use only the amount of force that was necessary to control the threat. If you go beyond that, and you try to get in the retribution side of things where you're teaching somebody a lesson, or you let your emotions take hold and you're angry about the situation that occurred and you're going to I'm going to make sure they never do this again to anyone else. If any force that is used beyond what is necessary to achieve control is essentially excessive and can present you with legal jeopardy if you engage in that.
So, and this is one of the big things I really wanted to hit on with you today specifically because you are uniquely qualified among about probably anybody else I know, because you have, I see everything through that rose-colored glasses of the law enforcement side. Now, yes, my wife spent probably 15 years working for defense attorneys, so we had some very interesting dinner conversations about cases back and forth and hypotheticals back and forth. But she wasn't an attorney. She got to do the office management paralegal work, and I've never been an attorney.
Mm-hmm.
You've gotten to walk both sides of that road, so you really have a really unique view on what's necessary and what's actionable as an attorney. So talk to us just briefly about that thin line that exists between defense and assault and how we cross that and how we don't.
Sure, yeah. So probably the best way to do this is by way of an example. Let's say, I'm minding my own business, walking down the street. Joe comes up to me and decides that, he just doesn't like the way I'm walking down the street. And so he comes up and he pushes me. Okay. So he is engaging in assaultive behavior by pushing me. So the difference in the law between an assault and a battery: assault is when you intentionally place somebody in fear of an unwanted physical contact. You can assault somebody without ever putting a hand on them. And then a battery is the completed touching. So when he comes up and he pushes me, he's committed an assault and battery. Now, if I respond to that, he's pushed me and he stepped back and he's giving me the mean mug and the face, and I pull my gun and shoot him. Well, I didn't need to do that in that scenario to control the situation or to control the threat. In Virginia, and this varies from state to state. State laws are widely divergent. Some states there's a affirmative duty to retreat. Some states there's what they call the stand your ground rule. In Virginia, there's a hybrid rule. And the way that it works in Virginia, if you are the innocent victim, in other words, you were minding your own business, you did nothing to bring about the difficulty, you didn't provoke anything, you didn't cause the fight, you didn't cause the problem, then there's no duty to retreat. And you can stand your ground and respond with the amount of force that is both reasonable and necessary in the situation. But if you caused the problem, if you were, antagonizing people, challenging people to a fight, you were the initial aggressor, then you have a duty to retreat and retreat as far as you can, and make known that you want peace and don't want any further violence before you would actually be eligible to use the amount of force necessary for self-defense. So it's a little bit of a hybrid in Virginia. But what that tells you is that line is a thin line between self-defense and assault. One, you can't be the one causing the problem, being the initial aggressor, going out with a chip on your shoulder, walking down the street, pushing people, challenging people to fight, anything. So you want to always be presenting yourself as, I was trying to avoid confrontation, I was trying to be reasonable, I was trying to mind my own business, and then if you have to use force, you always have to be cognizant of what amount of force is going to be necessary for me in this situation in order to defend myself without crossing that line to being excessive. And I were to put my hands up, say, hey, I don't want any problems, and he were to come at me again, and then I were to push him away. So, and then that's enough to make him turn around and think twice. Well, that was enough force that was both reasonable and necessary in the situation. But if I were to pull a blade or a gun and like, okay, I'm gonna, you should never put your hands on me, you touch me, and then I gut him or shoot him, that's not going to be reasonable. Now, ultimately, the jury gets to decide, the trier of fact gets to decide whether the force that you used was necessary and reasonable given the situation. So it's hard to come up with a bright line test because it is very, very fact dependent, and there really isn't a magic answer that this is what it looks like in every situation. It really does depend on what threat you're presented with, and there's a lot of variables that go into that. For instance, what might be objectively reasonable for a 115-pound female who's faced with a 250-pound, 6'5" male who's being very aggressive. That might look different than if someone were to come up to you and you're a big guy, built and relatively the same size, and then they push you. And if you respond with what the female might have been able to get away with, that might be excessive for you. So it really is very fact dependent.
What we call officer subject factors on the law enforcement side of it.
Yep.
Gotcha. So, but you still have to be very careful, like in that initial scenario that I presented where he throws a punch, you block, you hit him 10 times, you knee him 12 times, you kick him 2 or 3 times in the groin. You might have gone a little too far, and you might find yourself talking to the cops and sitting in front of a judge.
Absolutely. Again, what was necessary, and that necessity fact, the very nature of that word, there's some room for interpretation, and ultimately the jury is the trier. They're the trier of fact. They get to decide, and that's going to reflect the values of the community. And I think things have probably changed over the years. What might have been looked at as reasonable and necessary in the past might not be looked at in the same light today, both on the law enforcement side of things and on the civilian side of things. Sometimes you also have to remember that the members of the jury who might be deciding what is objectively reasonable and necessary, and it is a jury question, they are also sometimes misinformed by what they see in the movies and television. And I go, why didn't you just? I can't tell you this one. I've heard this so many times. Why didn't you just shoot them in the leg when they were shooting
Yeah.
at you?
Yeah.
Why did you have to shoot that? Why did you shoot the gun out of his hand? Why didn't you do the spinning back crescent kick that Chuck Norris does in the movies, and that's all that it takes. So, it could get really murky really fast, and that's why if you are ever faced with that situation, you want to have experienced counsel on your side who has access to experts who can testify to help inform the jury as to what necessity and objectivity would look like.
Gotcha. Well, that's what I wanted. That was my next point I wanted to bring up. What do we do in the aftermath of a self-defense situation? What do I say? Is there something I shouldn't say? Do I call the police? Do I not call the police? What do you think we should do after we've had the defense?
Yeah.
This could be self-defense with the hands. It could be whether I've been forced to pull some type of a weapon, whether it's a bladed weapon or a projectile weapon. But what do I do after? Should I even bother to call the police after I've been attacked? What do you think?
Yes. That's actually, you want to be, it's almost a race to 911. I mean, let me tell you what I mean by that. If you just say, okay, I've engaged in some sort of self-defense, whether it be a deadly force scenario or a non-deadly force scenario, but I've used force. If the bad guy has attacked me and I think, well, I've done what I need to do and I'm going to go about my business, I don't want to report it, I don't want to involve law enforcement. You don't know what they are going to do and the story they are going to come up with. And if they are the first one to call law enforcement, they get the first bite at that apple. And so they get to concoct the story of how you were the initial aggressor and they were just minding their own business and weren't doing anything wrong. And you were just a crazy person who assaulted them randomly. Or if in the case if you had to use something like a firearm or a bladed weapon, you're this crazy person walking down the street shooting people or stabbing people, and they don't know why you did that. So you do want to be the one to call 911. Now, you do want to be careful. In the aftermath of a self-defense scenario, that is not, you're going to be amped up on adrenaline. You're going to be dealing with the shock of the situation. Your mind might not be entirely clear. You aren't going to want to give the detailed narrative in that instant. And you don't want to do that over the phone either with 911. But when you call, you want to be, look, I was the victim of an attack. I was attacked. I was in fear of my life, or I was in fear. This is what's happened. If it's a situation where you had to use a firearm or a bladed weapon, you certainly don't want that in your hands when law enforcement arrive, because they're arriving. They don't know what just transpired. For all they know, there was a fight and somebody got stabbed or shot, and they show up on scene. And if you're waving a gun around, they might think you're the bad guy. So you want to, holster that or put it down, and you want to be telling the dispatch, look, I had to use a firearm, I had to use a bladed weapon, I don't have it anymore, my hands are going to be up, this is what I'm wearing. You want to say something along the lines of, I will press charges, or I will sign a criminal complaint. You want to put yourself in the shoes. I was the victim, and I will cooperate with law enforcement as necessary to sign a criminal complaint against this person who attacked me. The other thing that is a good idea to do, you would want to point out witnesses and evidence. Okay, and here's the reason for that. Witnesses sometimes walk away, so they might be the initial aftermath of an incident, and then there were some folks there that saw it, and then they might start saying, this is getting a little bit too hot for my liking, I'm going to turn around and walk away. So you could point out to the responding officers, hey, I think those people over there saw what happened. Hey, there might be a shell casing, or there might be, he had a knife and it fell down over there, because you don't want that to disappear. Somebody picks it up and walks away. Somebody steps on a shell casing because they don't know where it is, and it's in the bottom of their shoe, and they walk off with it. So pointing out evidence. And then you tell the law enforcement officers, I will speak with you. So sort of a checklist And I'm not inventing this whole cloth. One of the foremost self-defense experts out there, Masada, you came up with this, and I wholeheartedly endorse it as an attorney and as a law enforcement officer.
I heard
But
the same
you're
spiel from John
starting off
Thorne.
with, I'm the victim. Yeah, yes.
Yeah.
So um, I'm the victim. He's the bad guy. I will press charges. I'll sign the complaint. Here's where the evidence is. Here's where the witnesses are. I'll talk to you, but I want to talk to my attorney first. And then from that point on, those things you say nothing more. There's this misconception out there that I'm not going to call the police. I'm not going to say a word. If law enforcement show up, I'm going to just be talk to my attorney and say nothing more. The problem with doing that is that you miss the opportunity to put yourself in the shoes of the victim, because you weren't the one who called 911 in that scenario, and that you aren't telling the law enforcement officers who are responding that you are willing to press charges, you're willing to cooperate as the complainant. And then if the evidence walks away and the witnesses walk away and you don't have access to them anymore, that can be a problem for you. So it's a modified version uh, of I'm not going to say too much. I'm not going to give the detailed narrative until I have the opportunity to consult with my attorney and calm down a little bit and let the adrenaline rush die down. I can think a little bit more clearly, but I'm still going to point out those immediate things in the aftermath that are very important for the investigation that's going to take place. And I think that applies whether it's a deadly force or non-deadly force, because the last thing you want is Joe, who has attacked you, to be the first one to get the police there, and then they come up with this story and they get their buddies to say, like, yeah, you were the one that caused everything. And that does happen. And, if there's not any evidence on your side to show what really happened, that could be a problem for you.
So we've given a quick discussion on that fallacy of martial arts, the pretty much excessive hitting, punching, kicking, knee, and elbowing, etc., and how that leads to really flirting with that thin line between self-defense and assault, and then what to do in the aftermath of an attack when you've used force. Anything else that you'd like to give some tips on like protecting yourself from your own mouth, after you've talked to the police and there's charges and no charges pressed, and you're back in a locker room or maybe even at the dojo with your buddies and you start flapping your yap. Before we started, we actually spoke of a fairly famous law enforcement incident where one of the things that got those guys in trouble was they were sitting back in their locker room at their PD talking about, I haven't given somebody that big of a beating in a long time. Then you want to try to stand there and say, oh, well, I was scared. It's that dichotomy there doesn't quite work. And of course, it didn't work out in their favor either. But just give us some ideas on your thoughts on that.
Sure. Yeah. So let's say that you've had the opportunity to calm down and the adrenaline rush is over, and you have counsel who is going to advise you. They're going to tell you you need to be careful, like what you say. First of all, you can never lie. You lie about anything, and if you get caught in that lie, it damages your credibility. So even I've heard this myth. If I'm attacked, no matter how minor it might be, I will always tell the law enforcement, I take me to the hospital. I'm having chest pains, and that will give you the opportunity to let everything calm down. Well, if you make up a story about needing to go to the hospital, you really don't. That actually just undermines your credibility, and that could be spun to change the narrative that is not in your favor. Another thing, let's say you need to be careful about bravado. I taught that guy a lesson, and I'm never going to mess with anybody again. You never want to phrase things in that way. Everything should be couched in terms of, I only did what was necessary to defend myself. I was doing everything I could to avoid the confrontation. If you have to, think of, movie examples, you don't want to be Judge Dredd or the Punisher. You would want to be like Mr. Miyagi.
Right.
I am not out looking for trouble. I only do what is absolutely necessary and nothing more. I try to be reasonable, and I avoid confrontation whenever I possibly can. Um, and sometimes that means that you got to take a little bit of a hit to your ego, but ego will get you in trouble, both on the front side of things and then on the back side of things. If you successfully defended yourself, you don't want to be bragging about it. You don't want to be telling, embellishing and telling the stories about how great your skills were, and you certainly don't want to be bragging about how you injured or hurt somebody if that was the case. People who end up having to use force in a scenario, oftentimes it is a little bit sobering. If you've never been in that situation, when you think about it after the fact, particularly if it's a deadly force scenario and you either had to use deadly force or come really close to doing it, um, you know, you don't want to be out there pretending that you're Rambo or Judge Dredd, because that is going to look bad, and that the things that you say can be spun in a negative light, and that's actually something to be aware of when you're thinking about how to protect yourself from yourself.
Well, I think that's an excellent point. That sometimes we're our own worst enemy. So we've talked about, and let's just because
Yeah,
I know you and
for
I are
sure.
both, we are both big time martial arts guys. We're both DT instructors for the law enforcement side of things. Um, that's a huge thing for you and I, which means that you and I have done a lot of training over and over again. And most of the people we work with do just the bare minimum. They go through that block of training. When I went through
Yes.
defensive tactics in the academy, it was a week. I think our class now is just shy of 3 weeks.
Mm-hmm.
And a lot of those guys will go through that three
Mm-hmm.
weeks, get their pass on the sheet, never touch it again. Never. They won't do defensive tactics unless somebody comes in,
Yep.
right? Unless somebody comes in and says, hey, we're going to do this for in service, but yet they have to qualify with a firearm every year. And statistically, overwhelmingly, the majority of police officers in their career throughout the country will, while we may pull a weapon on somebody, don't have to actually shoot somebody throughout the course of their career. But even in small departments, you put your hands on somebody just about every
Correct.
day.
Yes.
So, give me some of your thoughts on
Yes. At least
your
to put handcuffs on them. Yes. Yes. Yep.
yeah. So, give me some of your thoughts on training and how it should, what level of realism you think they should be looking for as either
Yeah.
just as a
For
basic
sure.
civilian
Yeah,
martial
I think
artist.
both in yep, absolutely. Both with weapons and empty hand techniques. You must train in order to be efficient and to make that technique work under stress. Um, if you've practiced something 5 times in your life, and then you're in an assaultive situation where you've got to rely on that technique, you are not going to be able to remember that technique and do it against someone who's actively resisting you. It's just not going to work. You need to have done that technique 1,000 times and continue to do it, because just if you let that uh, you know sit for a while, you get really rusty, and the technique needs some refinement. You need to make it work. As your body ages, techniques that you used to do and used to work might not work for you anymore, and you got to go to something else. I found that to be the case for me. My whole jujitsu game has completely changed from where
Yeah.
it was back in 98. The way I played, not just from more experience, but just like things don't work the same way anymore now that I'm 45 that they did when I was 20.
It
You
gets worse.
you have to adapt. Yep. It just requires continual investment in yourself. Same with fires. I'm there's a bigger Second Amendment advocate than I. But to think that I'm going to buy a gun and that instantly is going to make me a self-defense expert when I've never even taken it to the range, that's foolish. Self-defense is more than having a tool in your hands for a particular technique. It also is mindset, it's pressure testing, it's putting yourself in the scenario, it's visualizing, it's thinking about what would I do both during and then in the immediate aftermath. And that does require consistent and constant training. And you need to put yourself in training where it's not just choreographed training. Like, for instance, law enforcement officers who go out to the range and they shoot a paper target and they run through the qual course once a year. If they ever have to draw that weapon in a pressure situation against someone who is moving with lots of other people around, and they have to think under pressure and identify the threat and then put rounds downrange, that's a different situation. And if you've never done it before because you've only shot a paper target, yeah, you're setting yourself up for failure. Just like if I've only done techniques in a controlled environment. One of the things that we talked about the DT update that I did, there are some places where, like in North Carolina, they have some academies that are under the community college system and some academies that are under a police department. Some of the community colleges will not let their instructors put a finger on a student in any situation. They're not allowed to touch them. They're not allowed to because they think, oh, it's too much liability. Well, I would say you're setting your trainees up for failure if you send them out on the street and they've never had a technique pressure tested and they've only gone through by the numbers with a completely cooperative person. That's not giving them the feel of what an actual self-defense situation is going to look like, or to make a control technique work against someone who is not going to let you make it work. So that is the one thing that really does separate things like jiu-jitsu, judo, boxing, Muay Thai, Kali, versus the more traditional martial arts where you only engage in point sparring, where you never put have someone who's really trying to prevent the techniques from working, or you do only the one-step sparring where they're going to come at you with a reverse punch and hold it there in midair while you do like 4 moves on the arm that's just outstretched. It's the aliveness of having somebody not letting you do the techniques. Now, does that mean that there's a higher risk for getting tweaked and injuries over the years? Yeah, I've had injuries over the years from training. But if you ever have to use those skills in real life, that means you need to practice with aliveness in order to make that work.
Yeah, I agree. I think some of the worst training I've ever been in has just been, hey, we're just going to do this technique, 10, 15 times, and then you never see it again. And then you're trying to do it for real, and it's just not going to fly. So, well, brother, I've taken up a lot of your time today, and I really appreciate your coming on and just talking to us.
Sure.
We have talked about the fallacy of martial arts training, the thin line between self-defense and assault, the aftermath of it, and then how to protect yourself from yourself and keep your ego in check post incident. And I really appreciate you coming on. You can always check us out at CenturionHoldingsLLC.net. You can contact us at CenturionHoldingsLLC@gmail.com. You can find us on all the social media networks. Check the QR code right there, and we'll see you next time.